Hello, everyone. How's it going? This is immigration attorney Moumita Rahman, and I'm here to talk to you about immigration and to see the questions that you may have on your mind today. Thank you so much for joining me today. We are going to do a special presentation on immigration options for parents of adult U.S. citizen children who want to fix their status inside the U.S. without having to leave. This is something that's really important, and I actually already have my first question on YouTube from Miguel Galindo regarding his mom and her options to fix. So let's talk about it. If you have a mom or dad who has been in the U.S. for years and years, and they entered the country illegally, they haven't had any status, and they do not want to leave the U.S., but they have multiple or maybe just one U.S. citizen child, is it possible for your mom or for your dad to fix their status without having to leave? Because you may have already gone to lots of attorneys, they may have spoken to lawyer after lawyer after lawyer and been told that there is no possibility for them to get a green card unless they leave the US for 10 years. So is this actually true? And what are the possibilities of them getting their green card if this is not necessarily true? So here is the answer to that. Whether or not your mom or dad necessarily needs to leave the US to fix your status is going to depend on multiple things. So in some circumstances, it may not actually be necessary for them to leave the US. If you have not entered the US with a legal entry, meaning that you crossed through the border without any sort of inspection with Customs and Border Patrol, and you now have adult U.S. citizen children, here are a few ways that you may be able to get your green card without having to leave. Number one, this thing is called Section 245I adjustment of status, which happens for people if you ever had a boss or a family member try to petition for you before April 30th, 2001. If you ever had an uncle, your mom's brother or their father, or like somebody that they used to work for, try to submit an application on behalf of your parent before April 30th, 2001, then your mom or your dad may be protected underneath something called Section 245I adjustment of status. And what this does essentially is that it basically kind of erases, it kind of forgives that one illegal entry, and it allows you to maybe petition for them and they don't have to leave, right? So one thing that is certainly required if you are trying to do the regular route of cases, meaning like if you are trying to petition for your mom or for your dad, is that they need to have the legal entry. So Section 245I adjustment of status is one way that you can kind of almost like erase that illegal entry and give them that permission to be here so that you can then petition for them. But Section 245I adjustment of status has a couple of big limitations. Number one, you obviously need to have had that family member or that employer file either an I-130 or an I-140 or a labor certification for your parent before April 30, 2001. And it really only forgives that one illegal entry. If your mom or dad has more than one illegal entry, just stay tuned. We're going to get to some of my top cases to help fix multiple entries, okay? Number two, the second way that you may be able to help your mom or dad fix your status is through something called military parole in place, which a lot of you may be familiar with. A lot of you may already have been told in the past that you need to go into the military to help your parents get status. And this is definitely a way, it's definitely an option, and it's available to either active members of the military or those who have served in the past. However, again, just like with Section 245I adjustment of status, this really only helps when you have that one illegal entry, okay? Now next, the third way that your mom or dad may be able to fix if they have an illegal entry without having to leave the US is through something called VAWA. Now, VAWA, it sounds really scary to some people. It stands for Violence Against Women's Act. However, it is a way that if you personally, you know what's happening in your own family, if you know that you've got that one sibling who is always giving your parents a hard time, right? If your sibling is being very super disrespectful, always, coming out of the house, never listening to your parents, giving them a hard time, getting into accidents, getting into alcohol or drugs, getting into trouble all the time, being disrespectful and yelling and cursing and screaming, taking money all the time. These are actually things that may have a greater effect on your parent than you realize, because when you are undocumented, yet you have that child who is not just giving you a hard time, but proactively telling you that you're not good enough, you're not a good mom, you're not a good dad, and also sometimes threatening with immigration or saying that you're illegal, you don't know any better, you should go back to your country. These sorts of things can be super emotionally harmful to you as a parent. And I do want you to know that there is a case called VAWA that helps people get green cards and helps people get legal status in the US based upon this sort of harmful behavior from a child. Now, the thing about VAWA is the fact that many parents are very afraid to do this case because, number one, you love your kids, so you don't want to say that they're bad kids, right? Maybe you believe that it's a reflection upon yourself, but the reality is that no matter how much you love your kids, they may still hurt you a lot, right? So at the end of the day, you deserve to be protected and you deserve to get a legal status of your own, no matter what, right? And if this is the way to do it, then I believe that you should think, you should give it some thought. Number two, this does not harm anyone. It does not harm you. It does not harm the child, because this is not something that's public. It is super confidential. It's private, and it does not go on your child's public record. Okay. Number three, if you have an illegal entry, this is a way towards getting a green card, especially if your child doesn't want to help you, right? If your son or your daughter doesn't want to help you, then really this is something that we should explore. And lastly, for those clients out there who have multiple illegal entries, if you have something called the permanent bar, sometimes we may be able to help you get your green card through VAWA, even if you have the permanent bar, okay? So this is a great tool. Next, this is for persons who also have the permanent bar. Now, this is one of my other favorite types of cases. It is called the T visa, and T stands for trafficking. And what exactly is trafficking? Well, hear me out, because a lot of our parents, as immigrant parents, a lot of parents have gone through this. And I have no doubt about the fact that so many people have suffered trafficking, labor trafficking inside the US, and just didn't understand that there is a legal way to get a green card, legal status through this. So if your mom or dad has ever work somewhere, you just have this feeling that their job treats them nasty, right? If you just know, you just have a feeling, even if your mom or dad doesn't want to talk to you about how hard it is at their job. If you have this feeling that your parents' boss is a nasty person and giving them a hard time, many times that sort of nasty, discriminatory, racist, abusive behavior can help your parents qualify for something called a T visa. And a person can get approved for a T visa and be on their way to a green card, even if they have multiple permanent bars, even if they have a false claim to US citizenship. There are lots of immigration problems that a T visa can fix. And lastly, if your parent has ever been the victim of a crime, or you yourself have been the victim of a crime that they have been a witness to, then they may also qualify for something called a U visa, which a lot of you already know about, which is for persons who have suffered some sort of crime. And the U visa it's taking a long time. However, it's still a way to get a green card for those for whom there may not be any other options, okay? So at the end of the day, the bottom line is that just because you have an illegal entry does not mean that there's absolutely nothing that can be done to get a green card, okay? Call our office at 212-248-7907 if you want to help your parents explore their options to fix their status and be on their way to becoming a legal resident of the United States, okay? 212-248-7907. And my team is ready and on standby, waiting to make an appointment for you. And let's go ahead and answer some questions. Thank you, everyone, for your patience. Now, my first question from YouTube for those of you who don't know, my name is Moumita Rahman. I am an immigration attorney. I have been practicing immigration law for the past 14 years. I am based in New York City. However, I work with immigration clients all over the United States. It does not matter to me what state you live in. If you have an immigration case that we work with, then we would be happy to see what we can do for you. And we work virtually with all clients, so there's really not a problem for us as long as you're okay with that. And for those of you who want to, who insist on speaking just to me, I thank you for your desire to speak directly with me. However, it's not possible for me to speak directly, which is why I have my incredible legal team, intake team, waiting to take your appointment and go through your options, okay? My first question from Miguel is, hello, can my mom qualify for VAWA if my brother is a resident? But I want to know if she can go for an I-360 for son abuse, from Miguel. Miguel, thank you so much for your question. Now, can your parent still go for VAWA if their son who is abusive to them is a green card holder but not a U.S. citizen? And the answer to that, Miguel, is that it is actually a requirement that your brother be a U.S. citizen. So a couple of options there. The first option is to see if your brother will apply for citizenship. So it depends on that. But second, if that doesn't work, then your mom, depending on what's happening in the relationship and how your brother is treating your mom, maybe she might be eligible for something called a T visa. Just give us a call so we can kind of help your mom go through those options. Okay, Miguel? Thank you for your questions. Anbu, hello, thank you so much. Larso is asking, in a VAWA case, can the abuser get denaturalized for getting a coyote to help the victim to get across the border? From Larso, that is a very interesting question. And if that was not disclosed and a waiver gotten for that, then possibly. But in a VAWA case, that doesn't have to be disclosed if you're worried about that. All right. Can I still apply for an I-601A even if I was granted my green card 7 years ago and my N-400 was denied because I didn't apply for the waiver from Najib Habash? That's really interesting. So you could try to apply for it. However, it might be very difficult. And one thing to do is to ask for something called an approval nunc-pro-tunc for that sort of a thing. But you definitely need to get your case analyzed. Let's Talk is asking, do you have a consultation with you or with someone else? Let's Talk, the consultation will be with my intake specialist. Let's see, I have a lot of joiners. From Jalpa Chabra, I'm an asylum seeker. If, for example, we get through the green card, can we take a citizenship for any other country, or we have to take up the USA only? From Jalpa Chabra. Jalpa Chabra, if you get approved for asylum or you get approved for a green card here in the US, there is actually no obligation to become a citizen of the United States. If you just want the green card, you can stay with just the green card. A lot of people don't want to actually become a citizen of the US because citizenship of the US brings about a lot of other requirements. But my advice would be is that if you qualify, if you get a green card and you're otherwise eligible to become a citizen, go for the citizenship, because in many cases, there could be some severe problems that you might encounter just by being a green card holder that you're not protected from. When you're a US citizen, you're actually protected from a lot more things, such as certain criminal convictions. When you're a green card holder, even if you've had the green card for 10, 20 years, if you get certain criminal convictions, you can still end up in deportation and lose your residency. Whereas if you're a US citizen and you have that very same conviction, let's say you get a conviction for possession or sale of cocaine, when you're a US citizen, you'll just go to jail, but you won't lose your green card, okay? Brownie, thank you for your question. And I feel like, I think you asked me this question last time, but you're my VAWA client, you got your EAD and I-131 approved. Is it possible to travel to India if you have advanced parole? So here is what I tell all of my clients. If you have been approved for advanced parole and you want to travel, but you're nervous, number one, at the end of the day, if you're super nervous about traveling on advanced parole, then take the path of least resistance and just don't travel. However, if you need to travel and you want to travel and you have advanced parole, generally speaking, we advise that if you don't have any criminal issues, it's usually okay to travel, but on every instance, even if you are our client, you should call us and talk to us, talk to the customer service team and to our legal team to make sure that there's no other problems for you to travel otherwise, because we have to check this every single time. Advanced parole does give you permission to come back into the United States, but this permission is still at the discretion of the Customs and Border Patrol agent who will interview you at the airport, and you still get taken to secondary inspection and asked certain questions. So you do have to be prepared, and you do have to have an understanding about what's going on in your case in case you get asked questions and the best way to respond to those things. And of course, if you have any sort of criminal issues or any other issues that your lawyers know about, then you have to understand that traveling with advanced parole always has a little bit of risk. But generally speaking, in our office, none of our clients have had problems with using advanced parole, but also we are very diligent and we say if you have any sort of criminal issue, don't take a chance and don't travel on advanced parole, because that could cause a trigger. My I-601A has been processing for 4 years, yet no officer is assigned to the case in Nebraska. Is that normal? From hi, yes, it is. I-601As are taking 3 to 4 years to process. How long does it take to make a decision on your I-485? I-485s can take anywhere from 6 months to 2.5 years to make a decision, depending on the category of case, location of your local field office, as well as whether or not the office is requiring an interview on your case. My I-485 shows that fingerprints were taken after 7 months. What will be the next step in a VAWA case? From Chirag. Chirag, when you file a VAWA case, one of the first things that clients ask about is, when will I get my work permit? And work permits, this is what you have to understand about a VAWA case. Normally, VAWA cases consist of both an I-360 VAWA application that we file together with the green card application. And when we file it with the green card application, we can also file for a work permit as well as an advanced parole. And when we do this, when we file all these things together, then you will definitely get an appointment for your fingerprints. And the fingerprint appointment can come, it can come anywhere from 3 months to 5 months after everything is filed with immigration. But really, at the end of the day, everybody wants to know, when will I get my work permit? So when you file a VAWA application, I would say that at this moment, the work permits are taking between 6 to 10 months to get. There's always some up and downs. Sometimes there are delays that we cannot control that are caused by the government. So a year and a half ago, the work permits were taking almost a year, and now it's down to 6 months to 10 months. But by the end of the year, it could go back up to a year. So it just goes up and down. And what I would say to those of you who are asking about how long will it take for this, how long will it take me to get this or get my fingerprints and all that, you really have to take all of this information with a grain of salt, because immigration, it's like a seesaw. It's like a wave. It goes up and down in terms of processing times. If you know that your general case is going to take a total of 2 years or 3 years or 4 years, temper your expectations. Otherwise, you will go crazy trying to figure out when the next thing is going to come. For VAWA, what kind of proof or records are needed to prove an abusive child for a parent with a permanent bar? From Letty. Letty, thank you so much for your question. That's a great question. If you are filing VAWA based upon your child, what sort of evidence do you need, especially if you have the permanent bar? Wonderful question, which is something that I really want to talk about with you right now. So generally speaking, when you are filing a VAWA case, Congress has actually made it super easy for you to file for VAWA, because They themselves, the law itself says that for VAWA cases, the type of evidence you can give is any credible evidence. So what any credible evidence means is that basically anything that can help support your case, as long as it does not contradict anything that you say inside of your case, or as long as it does not contradict or conflict with any outside information that is easily found online, right? So let me give you an example. If you say that you're in your affidavit that your son got into an accident in 2018 and drained your bank account, but you give a bank statement that says that the accident actually happened in 2021, then that would create a conflict, a discrepancy that might call into question the credibility. So that's why it's also very important to check all of your information. However, you don't actually even need that bank statement to show that your bank account was drained. Usually your affidavit itself is enough proof of abuse. It's enough proof of what's happened to you. It's enough proof of your story. But of course, we want to try to submit as much evidence as we can in as many cases as possible. So sometimes you can submit witness letters, you can submit text messages, you can submit, we've had a lot of cases where other children have helped write supporting affidavits, talk about what their sibling is like in a parent case. And also, one thing that I like to do where it's necessary is you can also do something called a psychological evaluation, where you go to a licensed therapist or a licensed psychologist, and they interview you, they do some sessions with you, and they make an evaluation about whether or not you have a diagnosis of depression or anxiety or some other sort of mental illness that may be caused by the relationship with your child and what stresses you're going through. And that is also evidence in your case that we can use, because in VAWA, we're looking for where, the basis of the VAWA case, whether you're filing VAWA based upon your relationship with your husband or your wife or with your child, is whether your child or your spouse has subjected you to physical battery or a pattern of extreme cruelty. And physical battery is any sort of physical assault, right? If you're pushed, if you're slapped, if you're punched, if you're kicked, if things are thrown at you, if you're physically injured, well, you don't actually have to suffer any injury. As long as there has been an unwanted physical touch upon you, that constitutes battery. So you don't need physical injury. You don't need bruises, you don't need pictures, you don't need police reports, you don't need any actual proof of physical injury other than what you say in your affidavit. And next, extreme cruelty and battery is emotional. Extreme cruelty is emotional abuse. So if your child or your spouse manipulates you, tells you that you're a bad person, tells you that you're uneducated or that you don't speak English and you should go back to your country, if you're cursed out, if you're disrespected and humiliated, if your money is used, if your spouse or your child takes your money, takes it away, or forces you into debt. We have a lot of parents whose children basically have forced the parents into debt by pressuring them, and guilting them into buying lots of expensive things like for quinceañeras, cars, certain things, damaging cars, and you're forced to pay everything. These things can all be a pattern of something that is called extreme cruelty, but all you have to understand about extreme cruelty is that it's emotional abuse. And here's the best way, ask yourself whether you have been feeling anxious, stressed out, depressed over what is going on between you and your child or you and your spouse. If you are having trouble sleeping at night, waking up, you're gaining weight or you're losing weight, you're not interested in the things that used to make you happy, if you're constantly stressed out and anxious, having nightmares, things like that, then 9 times out of 10, you are actually already suffering psychological abuse because of what is happening. And don't get it wrong. Just because you love your relative doesn't mean that they're not harming you. And if they're harming you and you're out of status, then you should do the best thing for you and get your legal status fixed so that you are not at the mercy of Customs and Border Patrol. You are not at the mercy of these government agents that are trying to actively deport you. This is an election year, and things may not be so stable in a year or so. So the time for action is always now, okay? The time for action is always now to find out what you are eligible for, to find out what the possibilities are, and to find out how you can secure yourself, okay? Call us at 212-248-7907. So Letty, to follow up on the second part of your question, for the permanent bar, again, it's the same thing. You know, honestly, the affidavit is the most important part for us to show how your perm bar connection is connected to what your child has put you through. Zinga the Queen, asking for a friend. If she is married to a U.S. citizen for over 5 years, who started the filing process for her but has stopped with continuing the case as he has now found another woman, what are the options for the friend? Zinga, great question. So let me rephrase this for you. If you started your immigration process with your husband or your wife, but now they have either left you or cheated on you and found someone else, what are your options? This is such an important question because many of you aren't in this situation. And here's the thing. We know that relationships may not always work out. However, when you're an undocumented immigrant who is relying on your U.S. citizen spouse to help you get your papers, and they fool around on you, they seek happiness elsewhere instead of working on your marriage, even though they know that that may harm your legal status and cause you to get deported. For me, I have rarely seen any cases where there's not other sorts of emotional abuse attached to this. And if that is happening to you, if your spouse is constantly making you feel guilty for trying to file for you, or they keep telling you that you owe them, or they threaten divorce and they threaten to cancel your case every time they're upset or they want to leave, that is a red flag. Those are such big red flags. And if you've been going through that for the past 5 years, and you still don't have your green card and you still haven't completed your case, and now to add insult to injury, they've left you for somebody else, that is just pain upon pain upon pain. And if that is happening to you, then most likely, well, we would love to see what you qualify for, and because you may actually be eligible to file a VAWA application and continue that immigration case by yourself. So Zinga, calls at 212-248-7907. Ok, desde John Mer. Abogada, ¿cómo está? Con permiso de viajar por TPS, ¿puedo salir a México a sacar mi pasaporte venezolano? Ya que lo me quitaron en inmigración, tengo una petición familiar desde John. Ok, John, parece que usted está venezolano y necesita viajar a México para renovar su pasaporte. Sí, y si usted tiene TPS y también tiene Advance Parole para viajar, sí, en muchos casos puede viajar a México para renovar su pasaporte, pero me acuerdo que tenía un cliente venezolana que tenía un poco problemas para obtener su pasaporte en México. No, para abordar el avión, porque su pasaporte fue expirado. Y para esto necesita una carta de su consulada venezolana que explica que su pasaporte tiene una extensión. Otherwise, no puede bordar el avión. Okay. My ex refuses to hand over marriage certificates so that we can get divorced. What can I do? From Bree. Bree, I'm so sorry to hear that. It sounds like your spouse is trying to manipulate you and prevent you from moving on with your life. If your spouse is refusing to hand over the marriage certificate, you can still, you're on the marriage certificate, so you can go to City Hall yourself to get a copy of that. You can also check online on something called Vital Check, where you can actually order certain biographic documents online, including marriage certificates. So if your spouse is refusing to give you a copy of the marriage certificate, please don't stress, because you are on the marriage certificate and you have the power to get a copy yourself. Go look up online for your county where you got married and how to obtain copies. Sometimes you can obtain a copy from court. Sometimes you can go to the marriage registrar and obtain a copy. But what if you are an immigrant, you don't have your green card or your papers yet, and you want to get divorced, but your spouse is refusing to give you the marriage certificate, or they're refusing to give you the marriage certificate so that you can file your immigration case? Well, if your spouse is doing that and they're a US citizen or a green card holder, then that is called emotional abuse, because that's manipulation right there. That is a direct action by your spouse that is made by them, intended to prevent you from leaving the relationship or being able to move on. And if that is happening to you, then there are probably other things that are happening to you, and you may be eligible to file an immigration case by yourself, okay? So call us 33212-248-7907. Is it true that started expedited processing to get the green card when you get married? From Joseph Moore. Joseph Moore, you can't really expedite the case unless you have an urgent reason to expedite. Ivan, sorry, not sure if you saw my question, but my dad was in a no-fault accident, needs 3 surgeries, and will be out for a year. Is there anything he can do? Ivan, I'm not sure if you're Ivan 1915. I'm not sure if you're asking about an immigration case. If your dad got into a no-fault accident, was it a hit and run or was it something else? I'm not aware of an immigration case that you can do through that, but if it was, I would say to get the police report. Get the police report. Was it a DUI? I don't really know. You're saying no fault, so it sounds like maybe not. But if you're the victim of a DUI or a hit and run and you get that many injuries, then there may be a possibility of a U visa in there. So give us a call, 212-248-7907. Can a case split while filing for my wife and daughter? Bling trending. So can a case split while filing for my wife and daughter while being an LPR, but I became a citizen while the filing got approved? Well, we just had a client have this problem. If you're a green card holder and you're filing for your wife and child, your wife and child can be on the same application and be on the same case. You don't have to do separate cases for your wife and child, but the minute you become a US citizen, you now have to file a separate application for your child, because you're now a US citizen and your relatives are each considered to be immediate relatives. So they do split and you do have to file a separate case for your child. Sea Butterfly, my husband has a 245I. I want to file for him. How do we start the process and how long does it take? From Sea Butterfly Girl. Sea Butterfly Girl, you start the process. You can give us a call, 212-248-7907. He needs to have some proof of that application that was filed back in the day. Some sort of photocopy is going to be good. We need proof that he's been here for a certain period of time and proof of your marriage and relationship. And the process, it can take anywhere from 6 months to a year and a half, depending on your local field office, because they will probably want to give an interview for him. So if depending on where you live, if you're doing a Section 245I adjustment to status case because your relative or employer filed a case for you before April 30, 2001, this case will usually require an appointment at USCIS for an interview. So based upon that, I would say average, it takes probably a year and a half. Punjab, please tell me asylum removal withholding I-360 approved, what to do for a green card, please tell. From Punjab. So Nick, thank you. Nick, thank you also for all of the gifts before. I didn't get a chance to say thank you. Thank you, Nick, on TikTok. So if you have a pending asylum case, however, you are married to a US citizen who is being abusive to you, who's mentally torturing you, and who's maybe even physically hurting you, you may be eligible to do a VAWA application based upon your marriage. Now, if you already have a pending case for asylum, you can still file this case. Even if you're in removal, if you have active proceedings, you can still file a valid case, but it requires extra steps and extra layers to the work. And it's very time sensitive, especially if you are in court. But you can give us a call, 212-248-7907. I'm a US citizen. I want to know if it will be faster if I sponsor my sibling or my green card parent. I'm from Zed. Zed, first of all, if you are lucky enough to be a US citizen and you have any relatives like siblings or parents that need to get their status, my recommendation is to just file I-130s for everybody, no matter how long it takes, because you never know what's gonna happen in the future. Now, generally speaking, if you want to sponsor your sibling, that will take approximately 14 to 20 years, depending on what country you're from. So if you want to sponsor your brother or sister and you're a US citizen, it can take anywhere from 12 to 20 years, depending on the country that you're from. And if you want to petition for your parent and you're a US citizen, that takes less than a year, and then your parent can sponsor, petition for your brother or sister, but that also can take up to 14 to 20 years. So either way, it's gonna take a long time for your sibling. And my advice to anyone who is thinking about sponsoring any family members is the time is always yesterday to have filed your I-130s, because the minute you file your I-130, you're putting yourself into a line, and the line just gets longer and longer, but it's moving up slowly and slowly. So just get your relative's application on that line, so at least you're reserving a place for them. Okay. Oh, YouTube. Sorry, I've been neglecting you, YouTube. What are some things that I should do after I get my green card from EDH? EDH, hey, haven't seen you in a while. All right, EDH, once you get your green card, here are some things that you should do. Number one, travel, because most of you have probably not left the country in a long time. You've been too nervous to travel outside. So if you have gotten your green card, travel. Second, make sure you are filing your taxes every year, because if you want to become a US citizen, you have to show good moral character, and you have to show that you have filed your taxes as a US resident every year. And number two, don't leave the US for more than 6 months at a time. Every time, even when you're a green card holder, if you leave the US for more than 180 days, then number one, it breaks the continuity of your residency, and it can be a problem for when you try to apply for your citizenship. And second, every exit out of the US for that period of time or more it gives Customs and Border Patrol the permission to basically ask you all these questions. So why go through that? How does USCIS investigate T visa cases? Do they contact the trafficker? Will you be deported if you are denied a T visa case? And how long does it take for an approval from Michael Michel or Michael Tate? Michael, thank you for all of your T visa questions. They're very important questions. So number one, if you want to file for a T visa because you were employed by someone who took advantage of you and treated you very, very poorly and was abusive to you in the workplace, USCIS does not investigate these cases by contacting your trafficker, because that is not their job. USCIS's only job is to either approve or deny your application, and they will approve your case if you meet all of the qualifications. And the qualifications are that that person or that company must have used force, fraud, or coercion to induce you to get labor out of you, to basically cause you to work not of your own free will, okay? It does not require that you be locked in a room. It can be mental shackles that they use to get work out of you. They could have used fear to get you to work. They could have told you that you'll be deported if you don't do something. They could have told you that you're not gonna get a job anywhere else if you don't do what they say, and they have to fire you. These are tools and tactics of control in the workplace that a trafficker may use. So So number one, USCIS's only job is to approve that case. They do not investigate traffickers. They are not a law enforcement agency. Now, as part of the T visa case, we, the legal team, we have to make a report to law enforcement of some nature that has the power to process and adjudicate traffickers. And that could be the FBI, that could be the police department, that could be the Department of Justice. And in a lot of our cases, all that we simply do is we simply write a letter to the Department of Justice saying, hey, we believe that Michael here suffered a trafficking situation with XYZ employer. We are submitting to certain details. It is then up to them to interview you possibly and investigate whether there is some sort of trafficking ring that they should investigate. But during the course of this investigation, there are still certain confidentiality rules that they have to observe. So they're not actually proactively contacting the trafficker to say that you yourself made an accusation of trafficking against them, but they may sometimes interview you to get more facts. I would say my opinion is that most law enforcement agencies are not really interested in prosecuting trafficking cases unless there's child or sex trafficking involved of a serious nature. But for the regular run-of-the-mill cases that the majority of immigrants have to deal with, I really believe that they just don't have the resources or the desire to go after persons who take advantage of immigrants. Next, how long it takes is about 1.5 to 2 years for USCIS to process the T visa cases. And lastly, I have not seen anyone get deported for these cases. But what I do tell clients, I am very proactive. I'm an open book when it comes to this. If I think that a client has certain criminal convictions that would put them at risk of deportation if they get denied, then I would advise completely against filing for a T visa. So if you have come through my office and you've had any sort of criminal conviction and we move forward with the case, it's because we have analyzed the convictions and we believe it's not a risk to you, but then we give you the choice, right? So this is a humanitarian case. So to answer your question, Michael, T visas are a humanitarian case, and the government is not really interested in trying to deport persons who are trying to seek humanitarian relief, because then it would have a chilling effect on you reaching out to protect your rights as a victim of trafficking or as a victim of crime or as a victim of domestic violence. So they're not really interested in doing that. However, if you have certain convictions that don't look good, like you have a conviction for rape or for murder or for torture, and you file for one of these cases and you get denied, then there would be an obligation on their part to report you for removal probably. But then again, any decent lawyer would never submit a case on those sort of facts. Okay, Michael, if you've been talking to our office, I think you have. I hope this will help you decide to work with us. You should not let fear of deportation prevent you from putting forth a good immigration case, because especially at the end of the day, the government, you're at risk of deportation either way. If you're walking around without status, especially depending on what state you live in, the risk is there no matter what you do. So my belief is that if you have been talking with us and we've told you that you may qualify for X, Y, and Z case, you really have to weigh the pros and cons about whether it's better to sit around with nothing and be a target, or take a chance and make sure, and make sure that you move forward in your immigration case. Okay. Anyway, that is all that I have to say for that. Maria, thank you so much. Danilo is asking, I applied for removal of conditions based on my wife, and I discovered she's having an affair with someone a year ago. I can't stay in this marriage anymore. What can I do? Thanks, Danilo. I'm so sorry to hear that you're going through this. This again is a situation that many people find themselves in. If you got your green card through marriage to a U.S. citizen and you got a 2-year residency card, and then you find out that your spouse is cheating on you, then what options do you have? Well, depending on what's happened, depending on whether they still want to help you, depending on whether you're getting divorced, depending on how they have treated you during this marriage while they're cheating on you with somebody else, you may be eligible to convert your joint I-751 application to an I-751 application requesting a waiver due to divorce or due to extreme cruelty and battery, okay? So Danilo, you may still have an option to change your case. Don't let your wife cheating or your spouse cheating on you prevent you from understanding what rights that you have, okay? Call us at 212-248-7907. Based on your 14 years of experience in VAWA cases, have you seen a case where the abuser is a green card holder and when he applies for citizenship, it gets denied even if there's no police report from Larsal? Larsal, I have not, because that would also constitute a violation of the strict confidentiality protocols they have. Will having a Section 245I in the past help me now to get my green card through my American citizen wife from Alawene, from Adnan? Adnan, yes, especially if you don't have the legal entry. All right. Wow, lots of messages, guys. Wilmer, does my tax debt fall into my sponsor or do I still have to take care of my own debt? Wilmer, you got to take care of your own taxes. That's not up to your sponsor unless it's your spouse and you file a joint tax return. My parents over 65 just got their green cards. How can I get health insurance for them? RDJ, you might want to contact your local hospital to see what resources they have. 30 days have been waiting for my receipt notice and I still haven't received it from Oracle, the trucker. Oracle receipts can take anywhere from 30 to 90 days to get, depending on the time of year. Married girlfriend paroled at Mexican border but never reported. Does she need pardon? From Joseph Navarro. Joseph, she may not need a pardon, but she might need to do other things. So you can call us if you'd like, 212-248-7907. Desde Karina, hola, tengo DACA, entre legal a los Estados Unidos, ¿qué posibilidad tengo de arreglar Green Card? Desde Karina. Karina, felicidades para su entrada legal. Es una cosa muy difícil para mucha gente, pero si usted tiene DACA, ya es necesario para tener un familiar para tramitar para usted, o si usted tiene una opción aparte de su familia, es posible, hay algunas posibilidades para una autopetición, ¿ok? Desde una visa T o una visa U. Carlito's Way, friend green card holder left the country for more than 6 months to care for a dying family member. Now they lost their status. How can they regain it? From Carlito's Way. Carlito's Way, and anyone who has a green card, and if you have been out of the United States for more than 6 months, you don't necessarily lose your green card just because you have left for more than 6 months. However, if you are outside of the US as a green card holder for more than 1 year, then Customs and Border Patrol will give you a hard time in re-entering the US, but you can explain to them why you never abandoned your residency. And what I would say is that when you are a green card holder, if Customs and Border Patrol tries to pressure you to sign an I-407 to abandon your green card, you should say no, and you should say that you'd prefer to go into proceedings and process this in front of a judge instead. So it may not be lost, but also, Carlito, sometimes there is something called the SB1, which is called a returning resident visa. That may be a possibility too. I want to file for my dad to get his papers. He did a voluntary departure over 20 years ago. What can I do to help him out? From Grand Balam. I'm really happy to hear that you want to help your father. If your father had a voluntary deportation, but he never left the U.S., then that means that voluntary departure, the voluntary departure converted into an order of deportation. But if they have a legal entry and now you are a U.S. citizen who wants to sponsor him, then you may be able to file an I-130, and we can try to reopen his removal order and get it terminated so that you can help him process for a green card. Call us at 212-248-7907. See, Butterfly Girl, you're welcome. All right. Nirmit. Yeah, Nirmit, if you are the spouse of a green card holder and your priority date is already current, we actually need to contact USCIS to try to get it moving along. This is the problem that we're having on several cases right now. So Nirmit, we will call you and tell you how we're going to proceed with that. But if your priority date is not yet current, there is no guess that I have about how long it'll take for that date to move. Viraj, if you're calling our office, we are going to ask personal questions because that's what we do. If you're not comfortable, I'm sorry to hear that. However, you won't be able to get in touch with me. You have to go through my team. And it's for an appointment, not with me, it's with my legal team. And I know a lot of people don't like this. They don't like, you want to speak with me directly. I understand that. It's just not something that we offer. So if you're not comfortable with that, I apologize in advance. All right, guys, that's all the time that I have for tonight. Again, thank you so much for joining me. My name is Moumita Rahman, and I have been a licensed immigration attorney for the past 14 years. And I love what I do. I believe immigrants make America great already. You deserve to know what your options are. Call us at 212-248-7907 for an appointment. We do have a consultation fee of $150, and it will be for an appointment with my team. And we really hope that we can serve you the best way possible, okay? Actually, I see one more question. So I'm going to answer this one last question from Viviana. My mother left voluntarily back in 2014 in Mexico. This will be 10 years. Is there a possibility for her return from Viviana? Viviana, if you're a U.S. citizen, yes, there may be a possibility for your mom to return, okay? Call us 212-248-7907. If your parent left, if they had the permanent bar or if they just had the regular 10-year bar, if 10 years have passed, we can frequently bring them back, okay? The process will take between 3 to 4 years, depending on what we might have to do, okay? All right, guys, have a great day and God bless. Bye.